Hello and welcome to this year's Have We Got Planning News for You MPPF special. Thank you all for tuning in either on YouTube, Apple Podcasts or Spotify. My name's Charlie Banner from Keating Chambers and I'm joined by the regular Have We Got Planning News for You panel. Apart from Sasha, who's in Australia watching the cricket, a far more fortunate experience than staying up all night, having had 2 hours sleep and reading the vast new array of MPPF consultation draft policies. Please can I remind viewers to consider making a charity donation in lieu of a registration fee. We include all the charities we support, including a new one on our website, havewegotplanningNewsForYou.com, or alternatively, please feel free to donate to a local charity of your choice. Now, without further ado, Paul, you're going to give us an overview of the consultation draft before we move on to the specific parts. So over to you.
I am, Charlie. Thank you very much indeed. It's 4 o'clock in the morning. It's just before Christmas, and we've got another draft MPPF. So thank you to government for arranging our Christmas special every year. There is an urban myth that there is a Chinese proverb, which there isn't, which says, "May you live in interesting times." It is quite clear that government believes that in some degree of measure. However, there is a little bit of a feeling that this is back to the future. When in 2012, government said, then the coalition government, that they were going to rip up the circulars and put it all into a sensible, coherent location, and that we're going to have a short national policy framework supported by PPG, I think few people believe them. However, it's been relatively stable and was relatively stable until it was first changed in 2017 and has substantively changed in 2020. Well, the current government are looking to do another radical change. It's not shorter, though. It's actually longer, and I'll come back to that in just a moment. There is a bit of me which has a huge amount of skepticism as to whether this is going to work, because at the time of economic difficulties, we probably want a bit of stability, and we probably need a profession that's got some familiarity with the rules. But no, government is now saying, no, we're going to have a radical approach. Although, again, back to the future, because there was a flirtation before 2012 in having policies within what were then planning policy statements, and then allowing those to all sort of be a national development management framework. Well, what we now have is we have an MPPF that's been reordered significantly. Policies have been inserted, and it's as if the Tories never happened. So we're back to 2011 again in relation to the insertion of policies. The important things are that bits of PPG which are thought to be important have been brought into draft MPPF, things like the standard methodology, like flood risk, like the tests in relation to green belt, as to how you apply grey belt, etc. They're annexes, and there's a bit of clarity that's been brought forward to intimate that the MPPG is intended to be supportive of MPPF. So it may very well be, Charlie, that's government nodding to say that Mead was probably wrongly decided, and here's a big hook where you can go back and have another pop and argue that MPPF takes precedence, which is actually what the press release said when MPPF was first produced. So there's a degree of sanity in relation to that. In terms of the restructuring, this is probably not shuffling the deck chairs on the Titanic, because there's been a huge amount of work that's been done in terms of the reordering of MPPF. In some instances, there's sense to this. In some instances, it's difficult to see why. But over the last 15 years, there's been a lot of flab that's been brought into MPPF. It's not quite the short, snappy policy document that perhaps we had seen back in 2012. The intention has been to clarify what are plan-making bits and what are development management bits. That is, frankly, to be commended. So when you look at each of the chapters, and I'll tell you what those are in just a moment, there are separations between policies which relate to just local plan making and policies which relate to development management. What's bound to happen is, well, what if you've got a bit in the plan making bit which has some relevance to a development management decision? Do we ignore them, or do we apply them as material considerations, or do we apply them as MPPF? Well, the courts are, I think, going to be troubled about the interpretation of this version if it comes forward as a final version in just the way that they were in 2012 with the radical change that we had when MPPF was first issued. The structure of the document, interesting. We've got plan policies and plan approach at the start. We've got plan making then dealt with. We've then got process-led parts in terms of MPPF. We've then got what I said to be the sustainability principles. I'll come back to that in just a moment. And then we've got specific thematic chapters which contain the National Development Management Policies. Still a bit flabby, but it's a logically structured document. MPPF has headed off. Plus ça change is what I've written down here with a big question mark. There are lots of things that stay the same, and my colleagues will tell you some of those things which stay the same in a moment. There are lots of things which are different, and I think it's going to take a few days of ploughing through to identify where there are different languages. So give you an example of that. Press the search button to look for valued landscape, that which has troubled the courts for an awfully long period of time. It's gone. Less than substantial harm. It's gone. It hasn't really, but I'll come back to that when I come into the policies towards the end. So lots and lots of changes, and there's some interesting things to be said about neighbourhood plans. I know that because Charlie sent me about 700 WhatsApp messages along with the rest of us over the night. I don't think he sleeps, frankly. Although just to let you again under the bonnet, which is what I said at the conference, before we started, Charlie spent 10 minutes telling us that his hair wasn't right, and good Lord, should I take my jumper off or not? Bless you, Charlie. You never disappoint. One thing I would stress, which I don't think has been covered by others, so hopefully thunder is not being stolen, though Chris is probably going to shout at me now and say, no, I'm dealing with that in 20 minutes. We've got a rationalisation of national validation requirements. That may seem the smallest possible point. It's Annex C. But what it does do is it makes making a planning application easier, because we're going to have national validation requirements, and you only deviate from that if you've got a development plan-based justification from doing so. So no longer do you go to Nowhere Borough Council says, well, actually, for the validation requirements, we need your zodiac signs and your shoe size. That's not happening anymore. We're going to have sensible validation requirements. We've also got some sort of zombie policies that are tucked away in there, and I'll be interested to see ultimately what my colleagues think in relation to DM3 and whether the duty to cooperate still sits there as a policy, even though it may be about to go in terms of a legal test. But there's still a hope that local authorities will work with each other. Good luck with that. And then in relation to other aspects, there is a significant reworking and a significant re-emphasis in relation to delivery of housing and also employment. So I would stress for those who saw my, what can I describe it as, supreme logistics show at the conference, just look at policy E3 and E2B3. Let me just say that again. E2B3, that's Roman numeral 3, followed by Arabic number 2. Get used to this. This is what you're going to hear all the time. It's interesting. So anyway, there's an elevation in terms of meeting logistics and freight need. Status, I've intimated at the moment, it's really important to remember, really important to remember, this is a draft. And it's really important that you give your feedback. This is not something to just tear apart and go, it's nonsense, it's criticisms. We can say that there are things wrong with it. Of course there are. It's a draft. It's being worked out by clever people behind the scenes. They're trying their best in relation to try and remedy things. But if there are things wrong with it, it's our job to tell them. And it's our job to tell them how in practice these things can be brought forward. So well done for not just tweaking things. Well done for not doing a go for a whole host of reasons. Thank you, Charlie.
Thanks very much indeed, Paul. So, is the document as radical as it's been suggested by government it is? Is it the more things change, the more they say the same? To quote a certain rock band, you'll probably guess who I have in mind. Is it giving with one hand and taking away with the other? For example, as we'll see later on, heritage protections have increased, local ecology protections have increased, the definition of age of veteran tree, which can be a showstopper, has vastly increased. I'm told by one arboriculturist probably being in tens of thousands of trees to the wholly exceptional circumstances protection before. Is this document as clear as it could be? Is it something which entails less ambiguity and legal risk than statutory NDMPs, which was the reason for not having statutory MPs? Well, lots of questions. Let's see if we get some answers. And Tora, you're first up. So you're going to tell us about the procedural policies and the presumption. So over to you.
Thanks, Charlie. Yes, I'm going to be covering chapters 2 to 4 of the consultation draft. So that's plan-making policies, decision-making policies, and achieving sustainable development. So chapters 2 and 3 are designed to be procedural policies for plan-making and decision-making. And they come ahead of the thematic chapters, which everyone else is going to cover, which deal with individual topics, which themselves split into plan making and decision taking. And as Paul said, that is, I think, to be welcomed in this document. So starting with plan making policies, this comes with a introduction, which is in a box. So government thinks it's important, which emphasizes the objective of there being a genuinely plan-led system. And these are then the policies which are supporting the measures which have been brought in by the Planning and Infrastructure Act. So it's setting out the tiered plan system that we're going to have. So your top tier is your spatial development strategy, then your local plan. You might have a minerals and waste plan. And then there's the potential for supplementary plans and also neighbourhood plans. And the clear emphasis in this chapter is every plan knowing its role. So we now, I think the most helpful part in this, or the newest part, is obviously in relation to spatial development strategies. So that's policy PM1. They are designed to be strategic with a positive vision for future growth and change. And they should cover at least a 20-year period. And they should apportion to local planning authorities their objectively assessed needs for housing and other uses. So they're also required to identify broad locations for strategic development, to provide a spatial framework for strategic investments. They should identify the green belt. They should identify broad locations for nature conservation, habitat enhancement, restoration, creation, set out broad location for strategic infrastructure, and then should be replaced every 10 years with alterations to local housing numbers every 5 years. So we there have a really sort of coherent encapsulation of what the spatial development strategies are designed to do. Local plans, PM2, policy PM2, they're proposed to sit under that. Very clear they shouldn't be duplicating anything in the spatial development strategy. They should plan for 15 years, and every 5 years there should be a commencement of a new plan-making process. PM4 deals with supplementary plans, and that these are to deal with specific issues. So, for example, design standards or situations that haven't been envisaged in the local plan but require some policy. And then neighbourhood plans, PM5, very clear that neighbourhood plans should not be promoting less development than provided for in other parts of the development plan. So a very clear hierarchy of plans. There's an emphasis, I think, on proportionate plan making. So PM6 includes general principles, and one of those is that plans should only include policies which extend beyond site or location-specific requirements where these are necessary, and where plan makers consider there is clear and justified reason for inclusion. So the expectation is actually you're looking to national policy for the general topics, for example, how you treat a heritage asset, that shouldn't be dealt with in the development plan, and you're really looking at the site-specific or locational policies. There's also an emphasis on proportionate evidence. So PM8 is evidence for plan making, requirement that it shouldn't be unnecessarily extensive. You should use existing evidence where it can be used, and you should also look to other plan making authorities and see if you can use some of their evidence. So trying to speed things up into the 30-month period. Cooperation. So the duty to cooperate, we know that's going. That's been announced recently. But we do still have a policy requirement for cooperation between local authorities, although it's now not going to be the absolute showstopper. So PM10 is the cooperate policy. There's a duty to engage proactively and regularly, and a requirement to make sure plan policies align as fully as possible where there are strategic interdependencies. We also have new soundness tests for spatial development strategies and separate ones for local plans not really time to go through those, but an SDS must be positive, appropriate, effective, and consistent with national policy. And a local plan must be positive, appropriate, realistic, consistent with the MPPF, and must be in conformity with the SDS. And it's just worth noting that amongst the soundness tests for an SDS is that a strategy which does not provide for objectively assessed needs should be considered an exception. So a clear emphasis on meeting needs. So moving on to Chapter 2, decision-making policies. Again, the theme in these policies is proportionate requirements. So Paul's already stolen my thunder on the information requirements for validation. I think that will be welcomed by the industry. The also interesting part of DM3, it states that when determining development proposals, local planning authorities should consult statutory or internal consultees only where necessary to do so, and decisions should not be delayed in order to secure advice from a statutory or internal consultee beyond their statutory deadlines, unless there's insufficient information to make the decision, or more detailed advice may enable an approval rather than a refusal. So government there trying to get a hold on delays being caused by consultees not providing responses. And then DM9, I think, is worth note, strong encouragement to local planning authorities and mayors to use local development orders and mayoral development orders where that would support housing, regeneration, economic growth or environmental improvement. But I want to come on now to Chapter 4, which I think is one of the chapters that is going to take on a particular interest and comment. This is the chapter which has the new presumption in favour of sustainable development. So we have that set out at policy S3, and it is that decisions on development proposals should apply the presumption. And what that now means is that if you are in a settlement, that is set out in policy S4, and if you're outside a settlement, that's in policy S5. But then there's also the stipulation that in all locations, if you comply with an up-to-date development plan and also the decision-making policies of the framework, then you should be approved without delay. So coming on to S4 then, the principle of development within settlements. I mean, the first point is there might be very many locations across the country where it's not absolutely clear whether you're in a settlement or outside of it, particularly if you don't have defined settlement boundaries. So I can see a number of arguments over that stipulation, that policy. This provides that if you are within a settlement, you should be approved unless the benefits of doing so would be substantially outweighed by any adverse effects when assessed against the national decision-making policies in this framework. So an automatic tilted balance, if you will. And note, yes, substantially outweighed. So possibly a different tilt, whether we're dancing on the on pinheads there, I don't know. It then goes on to say the circumstances in which the benefits of approving development are likely to be substantially outweighed by adverse effects include a number of scenarios. I'm not going to go through all of those. It's 3 scenarios, but the last one of those is a failure to comply with one of the national decision-making policies, which state that development proposals should be refused in specific circumstances. So essentially, if you don't comply with one of those policies, you are out with the tilted balance. And again, I can see difficulties there. Is the particular policy requiring refusal in specific circumstances, or is it just indicating it's a factor that should weigh against you? So I think that's going to be there's going to be scope for argument there. And then policy S5, principle of development outside of settlements. So this is a really interesting policy. Only certain forms of development should be approved outside settlements, as set out in the following list. So we have a closed list from A to J of S5, where development should be approved outside of settlements. And it says, unless the benefits of doing so would be substantially outweighed by any adverse effects when assessed against the national decision-making policies in this framework. And there's not time to go through all of those, but there are for example, one of them is the redevelopment of previously developed land, limited infilling. But then just to turn to H, development for housing and mixed-use development, which would be within reasonable walking distance of a railway station, which provides a high level of connectivity to jobs and services, physically well related to a railway station or settlement within the station, which the station is located, of a scale which can be accommodated, taking into account the existing or proposed availability of infrastructure, and where the development would not prejudice any proposals for long-term comprehensive development in the same location. So that's the much heralded railway station presumption that the government had announced previously. Also, J, development which would address an evidenced unmet need. And so that could include possibly a 5-year housing land supply deficit, and where the development would be well related to an existing settlement and of a scale which can be accommodated taking into account the existing or proposed availability of infrastructure, or comprise major development for storage and distribution purposes, which accords with the relevant policy E3. But again, it's important to note that we have the stipulation that circumstances in which benefits of approving development proposals are likely to be substantially outweighed by adverse effects include, but are not restricted to, situations where the development proposal would fail to comply with one of the national decision-making policies that state that development proposals should be refused in specific circumstances. So judgment there, so it's not necessary that you actually do contravene one of those policies, could be broader than that, it's open to the decision maker. But also that point about what is the policy directing refusal or not. So I think there's going to be a huge amount for lawyers and planners to argue about in that paragraph. So with that, I'll hand back to you, Charlie.
Thanks, Dora. Just one observation from me on that before passing on is it's under the current MPPF, of course, even if there is a 5-year housing land supply, and even if the housing delivery test has been passed, there's a gateway to the tilter balance for unallocated greenfield development in the event that the most important development plan policies are out of date. For example, settlement boundary policies, for example, and Persimmon's victory in Soham, Cambridgeshire, is quite a good illustration of that. Not so anymore under S5. If the council has got a 5-year supply, and if the HDT has been over 75%, then outside settlements there'll be a presumption against development, rebuttable only in exceptional circumstances, even if the housing supply is 5 years and 1 unit, and even if the settlement boundaries which the development is outside are woefully out of date. So that's quite interesting. Anyway, Thea, you're going to tell us about the climate change and clean energy aspects of this. So over to you.
Thanks very much, Charlie. I've got a bit to say on Chapter 5, Meeting the Challenge of Climate Change, and Chapter 10, Securing Clean Energy and Water. And I am cautiously optimistic this morning for energy development. I'm going to dive right in with policy W3, because my plea that I've expressed a number of times has been answered. This replaces paragraph 168 of the current NPPF, and it's the culmination of a strengthening presumption for renewable and low-carbon energy development from the move in 2024 to significant weight to the benefits associated with those projects. And now we've landed on substantial weight, which I think is positive, and it's part of the move to streamline the terminology in this document. And substantial, I think, is that weighting at the top of the scale, and that's positive. And so is the instruction that you give the weight to improving energy security, supporting economic development, and moving to a net zero future in respect of those projects. The new policy, W3, separates out those things and recognises them as distinct benefits of this type of project. And that's wider than the previous paragraph 168, which simply referred to or instructed giving significant weight to the benefits associated with renewable and low-carbon energy generation and the proposal's contribution to a net zero future. The drafting doesn't actually resolve whether that's one weight or whether it's separate weights to each of those benefits. So I'll be making some comment on that in my consultation response, because they are distinct benefits and there is a risk on the current drafting that those benefits are lumped in together and given a single weighting. And in my experience, decision takers often give separate weight to each of those matters. So I think that clarification would be helpful. The repowering, life extension of renewables, low carbon and energy infrastructure, that also receives substantial weight. So too do community-led and small-scale projects, rather than merely recognising their valuable contribution as per the current paragraph 168B. There remains no requirement to show the need for a project like this, and the wording of W3 2 also extends to electricity network infrastructure. The inclusion of that infrastructure is important in light of grid reforms. They're taking place. That upgrade is urgently needed, of course, to meet Clean Power 2030 and longer-term net zero ambitions. If a scheme comes forward outside of an area in a development plan that's been earmarked for this type of development, then previously applicants had to demonstrate that the location was appropriate by reference to the criteria that was used in identifying that area as being appropriate. Now, that hasn't really been much of an issue, since development plans rarely, if ever, identify allocations or even broad areas for energy development. But now, proposals outside such areas should be acceptable when assessed against framework policies as a whole. And that's likely to be more important because, as I'll come on to, the consultation takes a much more positive approach to plan-making authorities identifying land for energy development. There's a new requirement to add decommissioning and site restoration proposals for time-limited applications. That just reflects common practice. I don't think there's anything new there. And W4, that ensures that substantial weight is given to proposals for water supply, drainage and wastewater development, and that the need for such infrastructure doesn't have to be demonstrated. So what these policies together really represent is an identification of how important these infrastructure projects are. I think, well, for renewable and low carbon, that's been obvious for many years now. We need a significant acceleration of that type of development coming forward, and this obviously supports that. The inclusion of water infrastructure is also really helpful, and I think is a recognition of issues that are continuing to crop up in respect of that sort of infrastructure, and tries to plan and determine those applications in a more comprehensive and positive way. On to the plan-making part of this chapter, paragraph 165 is replaced by W1 and W2, and the key points on that is that there is stronger wording now on the role of the development plan, and a requirement to identify areas suitable for renewables where this would help secure their development. That, of course, has to be done following engagement with providers, regulators and network operators to understand where there is capacity in the grid to connect such projects. Without that coordinated approach, which is set out in the draft document, allocations for growth could well be useless. Previously, plans had to consider identifying suitable areas for development, and now plans should make provision for new or enhanced renewable and low carbon energy development, electricity network infrastructure, water supply, drainage and wastewater infrastructure, whether that's as part of development proposals or as standalone projects. So that is a much more coordinated approach to infrastructure, which asks local planning authorities to address this at the earliest possible stage, having regard to all of the information that's required to indicate where those projects need to come forward, where capacity is, and where there are going to be shortages in future. But in identifying areas for renewable and low carbon and electricity network development, that is, I think, closer to allocating land. That should be done where it helps to secure their development and maximise the potential for suitable development. And I think arguably that falls short of requiring allocations if the local planning authority can point to more general policies in the plan supporting this type of infrastructure, and indeed the framework which would support development in their area. There are no substantive changes on decentralised energy and heating. I want to touch briefly on Policy S5 and the presumption as it relates to development outside of settlements. S51B includes a presumption in favour of infrastructure, including for transport, energy and water. And that's obviously sensible since most large-scale energy schemes are in the countryside, but that's a point which hasn't been terribly controversial in relation to those schemes in any event. So it rationalises the position. I don't think it's something new. Turning to climate change more broadly in Chapter 5, Policy CC1 is planning for climate change, and that consolidates current policies 161, 162 and 164. It uses strengthened wording to indicate what is hoping to be achieved, and that is a radical reduction in greenhouse gases. Spatial strategies and allocations can be informed by an assessment of baseline carbon emissions and the potential effect of development options on future emissions and their mitigation to demonstrate radical reductions. Development plans should also identify opportunities for nature-based solutions, which can safeguard and improve carbon storage, defined in the glossary to include the creation of woodlands and wetlands. CC2 is mitigation. That replaces current paragraph 163, expanding on considerations of climate change in decision-taking. And key considerations in that include sustainable transport, design approaches aimed at conserving energy and resources, reuse of existing structures and materials, taking advantage of opportunities to draw low-carbon energy from decentralised networks, contribution to restoration of carbon-storing habitats, and no increased fossil fuel extraction unless it's in line with M5, which starts by saying proposals for extraction of peat at new or extended sites should be refused, and then narrowly define certain other development where extraction has to be necessary. Paragraph 2 of CC1 says that substantial weight should be given to the benefits of improving the energy efficiency of existing buildings and or drawing energy from district heat networks, renewable and low carbon sources. CC3, that concerns adaptation. It replaces the current paragraph 163 and requires proposals to take into account current and potential impacts of climate change over the lifetime of schemes. In other parts of the draft, there are updated definitions of renewable and low carbon energy. That includes energy for heating and cooling, as well as generating electricity. Renewable energy covers those energy flows that occur naturally and repeatedly in the environment, including wind, water, oceans, sun, biomass, deep geothermal heat. Low carbon technologies are those that can help reduce emissions compared to conventional use of fossil fuels. And we see in this part of the definition the inclusion of battery energy storage systems, as well as a range of other technology. With grey belt, there's no substantial change to grey belt policy for renewable energy, low carbon purposes. Paragraph 160 on the very special circumstances as they relate to renewable energy and low carbon schemes, including the wider environmental benefits, that's retained at GB6.3. And then I just wanted to turn briefly to the two biggest issues for renewable and low carbon energy schemes. And the first of those is landscape and changes to landscape wording in N21A, which is to consider the environmental qualities of land proposed for development, including habitats, landscape character and the natural beauty of the countryside, and identify opportunities for those qualities to be conserved or enhanced, including through requirements for biodiversity net gain, I think is helpful because it's saying that one can contribute to the environmental qualities of the land for the purpose of that paragraph, where qualities can be conserved or enhanced, which might be the landscape elements, for example, of trees and hedgerows, which one would be looking to enhance through, for example, biodiversity net gain. So I think there's a route through there to saying, even if a scheme does impact on the intrinsic character and beauty of the countryside, or as it said now, the natural beauty of the countryside, if that scheme can come forward in a way that respects and enhances certain landscape elements, then that can be acceptable. BMVAL, best and most versatile, that's still there, N2B. That's another area where I'm going to be making a response, because we need a much clearer policy on this, rather than the confusing use poorer quality agricultural land in preference to that of higher quality lands. The courts have confirmed that doesn't require an assessment of sequentially preferable sites, but often that's what's expected given the preference that's expressed there. And of course, that doesn't just relate to renewable and low carbon energy development. That's across the whole spectrum of development. So we need better policy on that. On heritage, there's been a consolidation of heritage paragraphs with the aim of clarification, but no substantive changes for renewable energy and low carbon schemes. One must now give substantial weight to the conservation of assets, which is not intended, in my opinion, to be any different to the previous great weight. What that's about is streamlining terminology, but the policies as a whole probably leave some room for improvement. Thank you very much, Charlie.
Thank you very much indeed, Thea. Chris, you're next up. The Delivering Homes and Supporting Growth is the title of the next section of the framework, something which every iteration of the framework has claimed to achieve. How does this one fare?
Well, it gets a big thumbs up from me. And I have to say, I understand why there are some concerns around S5, development outside of settlements. But of course, the exemption to that is if there's a lack of 5-year land supply. And if you look around the country, the overwhelming majority of the country now has a lack of 5-year land supply. Charlie and I both have appeals in the same town in Wiltshire next year, and the shortfall in Wiltshire is over 10,000 homes in the 5-year land supply. So I don't think anywhere in Wiltshire is going to be able to ward off development outside of settlements, certainly in my lifetime. The position then is that this delivery of homes and supporting growth is chapters 6 through to 11. Thea has dealt with chapter 10, so I'm going to focus on the other chapters, and in particular housing and the economy, because much of the section on town centres and communications is the same, although there are some changes on specific reserves for minerals, which is very welcome as well. And just to reiterate Paul's point, this is all consultation. The government has put in a huge amount of effort into this document, and all the civil servants that are working on this. And what they now want is our responses. This is a consultation that goes on till the 10th of March. And I have to say, in previous consultations, the development industry has allowed itself not to speak with a unified voice, or not even to put its arguments across. And huge amounts of the consultation responses come from objector groups, residents groups, and NIMBYs. They far outweigh the development industry. So I echo what Paul said. If you want any of this to actually take shape, or if you want to change it, as Thea has helpfully indicated, then you've got to engage in the consultation. Why am I so positive? Well, it starts out at the section on delivering sufficient supply of homes with a clearly stated objective. And the objective is that the policies should support the delivery of a substantial increase in the supply of homes. If there's one word that permeates this entire document, it is the word substantial, which is the weight to be given to new development. And in this particular objective, a substantial increase in the supply of new homes. Previously, and in the current paragraph 61, we had the objective to significantly boost the supply. But I think substantially increase is a higher objective. I think it shows more immediacy and more weight to be placed on the delivery of homes. It's also clear about this isn't just about housing anymore. It's about an appropriate mix of accommodation. So that means that there should be substantial increases in specialist accommodation for the elderly, accommodation for students, accommodation for military personnel. It extends to C2 uses and also to travellers' sites as well. In the chapter on housing, chapter 6, there are 13 policies in the new layout and set out that we have. 6 of them relate to plan making and 7 relate to decision taking. Policy HO1 is assessing the need. And of course, as Tora has said, we are seeing in the policy the introduction of the spatial development strategies. And so this policy starts with the idea that assessing need is done at the spatial development strategy level. There should be a housing need assessment that establishes the overall number of homes needed as a minimum using the standard method, as well as the need for permanent and transit sites for travellers, and what's described as an understanding of any accommodation needs that can't be met in neighbouring areas. From there, we then get an assessment of the size, type and tenure of housing and other accommodation. So again, bringing C2 into what needs to be considered by way of accommodation needs of all sections of society. Policy HO2 is setting the requirement figures for housing. So we've got our need figures set out using the standard method. Obviously, local plans don't always have to adhere to that, and this is the reference to requirements. But it's, again, the spatial development strategy should establish the housing requirements for each local authority area. And then the government says in this policy that should not be retested at the local plan preparation stage. So we are sweeping aside the whole objectively assessed need or standard method figures for individual authorities deciding what they then want to do as their requirement. It's all going to be in the spatial development strategies, and amen to that. Unless it says there's a significant change in circumstances which affects the overall requirement. Now, I can see lots of consultants who work for local authorities trying to help members to adopt plans with lower numbers, relying on that sentence to reduce the local plan figures. So my consultation response will make clear that actually we don't need that caveat. Basically, it should all be in the SDSs. But what happens when we don't have an SDS in place and there are local plans being promoted at the moment? Well, again, policy HO2 is really clear on this. It says where an SDS is not in place, local plans should establish the housing requirement for their area, taking account of any relevant emerging SDS. So it's no good saying, well, the SDS hasn't been adopted, so we're not going to look at that. What local authorities will have to do is have to take account of what is in the SDS. And I can imagine most local plan inspectors saying you're ignoring that much higher figure that's set out in the SDS, and as a consequence of which your plan will not be found sound. Housing requirement figures, these should reflect the extent to which there are identified needs in the area, obviously based on the standard method. And it can, in fact, be a higher figure. So you can go for higher figures, which is currently the policy as well. But there's also a need to consider, obviously, the constraints in the area. There's a requirement now for pitch and plot requirements for traveller sites. And then turning to local plans, these should now set out the figures for the designated neighbourhood plan areas. Now, we've presently got that in slightly tepid form in paragraph 69, but many people are saying, and this is an issue for me and Charlie in Wiltshire, what about neighbourhood plans that are adopted but don't have a housing requirement that corresponds to what's needed in the area? And this is a policy making clear that local plans now should identify what the housing requirement is in each designated neighbourhood plan area, instead of having neighbourhood plans just deciding how much housing they want to do or going for a much lower number. Unless it's impractical to do so, and various exceptions are given to that, the figures for the neighbourhood plan areas should take into account the following factors: the latest evidence of local housing need, the population of the neighbourhood area, and the most recently available planning strategy for the local planning authority. So neighbourhood plans are now being put firmly into a position where they should respond to what is ultimately set out in the SDS via the local plans. And it will be the local plans that set the targets for the neighbourhood plans areas. Local planning authorities should avoid allowing any area to have a nil housing requirement, although there are some exceptions, such as if all the housing had already been met, but I can't see that being the case. Policy HO3 is providing land for homes. Local planning authorities should provide sufficient supply, and in so doing, we see the familiar supply of specific deliverable sites for years 1 to 5, and then the broad locations and developable sites for years 6 to 10, and if possible 11 to 15. So that's just reiterating existing policy. But we interestingly also see those requirements for the first 5 years and then the next 10 years being applied to travellers' sites as well. And then there's also a need for a trajectory for the expected rate of housing delivery and for traveller pictures and plots. Policy H04, land for large-scale residential and mixed use. In the current MPPF, we have a policy that identifies the need for sites for small and medium-sized developments, but this is a specific policy for large-scale developments. Every local authority should be planning for large-scale developments, including new settlements, urban extensions, and urban quarters, identifying that for the urban conurbations, where it's not possible to have new settlements and urban extensions. So large sites are required everywhere. There was a reference to new settlements and urban extensions previously, but this is a specific policy requiring land for large-scale residential and mixed-use development. Meeting the needs of different groups is set out in Policy H05. That's obviously affordable housing. There is no 5-year requirement for affordable housing. That's a shame, and I think we should have that, as well as having 5-year land supply for market housing and for travellers' sites. You should identify sites for a range of different groups, as we've already covered, housing for the elderly, student accommodation, and gypsies and travellers, and a new policy that requires the setting of the mix of tenures for sites of 150 houses or more. Policy H06 is planning for a diverse mix of sites. We've seen already in paragraph 73 of the present MPPF that local authorities are required to meet 10% of their housing requirement on sites of no larger than 1 hectare. But the new policy we have is to add a further 10% for sites of between 1 and 2.5 hectares. And this is obviously to help the small and medium-sized building industry. And I'll just depart from the MPPF there and refer to the other document. 2 documents have been published. One is about the proposed reforms. And in there, we see, I think, the most positive and undoubtedly enthusiastic support for the small and medium-sized house building sector. The government is fully aware that small house builders and medium-sized house builders are disappearing all the time. We're all familiar with companies that had a house building arm but are instead just focusing on strategic land at the moment and not pursuing their housing arm or housing companies. The government has taken really radical action here. What they are proposing is a new category, and this is, as I say, in the other document, the consultation on the reforms, a new category of medium-sized sites. So we get away from the absurdity that is that everything of more than 10 units is considered a major site or a large site. Developments of between 10 and 49 homes will fall into the new medium category, medium developments, and also sites of up to 2.5 hectares. And within that, the government is consulting on all kinds of exemptions from the building levy, from biodiversity net gain, and improving and uplifting the planning in principle, all for these medium-sized developments. And so we can see real emphasis being placed on that sector and trying to alleviate some of the burdens that sector has suffered and has caused a number of companies to not progress their house building arms. Decision-making, Policy H7, meeting the needs for homes. This reiterates that substantial weight will now be given to the benefits of providing accommodation that will contribute towards meeting needs. And that's obviously an upgrading of the weight and significance to be attached to that, albeit we all know the Secretary of State inspectors usually give substantial weight to this in the absence of a 5-year land supply. Policy H08 is providing affordable homes. Now, there's some flexibility here that's been introduced, and I suspect from the examples and the experience in London, proposals should meet or exceed their development plan requirements. So no question about not being SIL compliant if you exceed the affordable housing requirement. That's actually positively to be welcomed. It should be done on site, but if it can't be done on site, then it can be done by delivering the affordable housing on an alternative nearby site if this would optimize the quantity and quality of homes. Now, this is a policy that Westminster have, which is that you can effectively deliver your affordable housing elsewhere. And it's something that is now going to apply to the rest of the country if this policy comes in. And also there is the option of cash payments in lieu, if that can be justified by robust evidence. Development proposals that include military affordable housing, that's a new term, military affordable housing, will not be required to meet development plan requirements for the mix of housing. I can see that on MOD sites like the John Moore Barracks in Winchester, where the MOD might decide that actually the affordable housing they provide is this new military affordable housing. And then a really interesting policy is that if you exceed the requirements for affordable housing, the local authority are being told to take a flexible approach to the size requirements for market housing. So market housing can be approached in a more flexible way if you over-provide on the affordable housing. What we see is repeated references to the government being very supportive of proposals that meet or exceed their affordable housing requirements. Policy H09 is specialist forms of accommodation for elderly people. And there's a new emphasis on having this type of accommodation provided and having policies that support it and sites that provide it, but also there is an emphasis on accessibility to services, facilities and public transport. There's more detail on specialist community-based accommodation. So these are the community land trusts and so on, and also for purpose-built student and large-scale accommodation. I'm not going to cover the exception sites, isolated housing in the countryside or travellers' sites, because that is all familiar in the existing MPPF. But I will briefly mention HO13, which is the build-out. And here we see the government reiterating the emphasis you find currently in paragraph 81 on reducing the time limits for the submission of reserved matters and commencement of development, which seems to be an obvious thing to do if you are pursuing a case on the basis of a shortfall in the 5-year land supply. Very briefly, because there's a lot of material here, building a strong and effective economy. A lot of this is very similar, but we do see new references to campus facilities, generating capacity to assist data centres, and Paul will be pleased with this one, a reference to last-minute deliveries for storage and distribution. Reference to support the leisure and tourism industry is also included, and that will be very welcome news to clients in Cornwall and Devon. Reference in policy E2 to AI growth zones, where you can't not mention AI these days, can you? And also the benefits of food production, animal welfare, and the environment. So there's a beefing up of the section on the economy. The key difference, though, is policy E2, meeting the need for business, land and premises. This is one of Paul's pet hates, is the fact we don't have targets and so on for logistics and for other types of employment. It's a well-made point. What we're seeing here is substantial weight, again, being given to proposals for commercial development if businesses want to invest, expand or adopt, and added emphasis to the benefits of domestic food production, animal welfare and the environment, as previously mentioned. But also, if you're proposing development outside of settlements in line with the requirements of policy S5, consideration will now be given to market signals that indicate an undersupply of specific types of land and premises. So there's a lack of logistics provision. Development outside of settlements will be allowed based on the market signals. So it's not like a 5-year land supply, but it is, of course, looking at the supply and the rates of take-up. And that's now identified in policy E2. And whether a development proposal's specific location requires infrastructure, and there's more emphasis on the handling of goods, but not just the handling for storage and distribution, but also the processing and interchange of goods. So lots of support for economic development. There's a specific policy on freight and logistics and a specific policy on rural businesses, which includes new references to farms having on-farm reservoirs, greenhouses and polytunnels. As I say, ensuring the chapters on town centres and communications and minerals are largely the same, but just finally, there is a new set of reserves required in the minerals chapter, a 10-year supply of individual silica sands, 15 years if that involves significant investment, 25 years of reserves for brick clay. So there's such an emphasis on new building that there's a need for a lot more brickworks and cement and any support for new kilns. A 25-year reserve of brick clay, which is an incredible addition to the emphasis on growth. And then finally, there's support for substitute or recycled materials and the need to provide for those. A lot of emphasis on growth. There's a whole new section on viability in the consultation document. That isn't setting any land value targets or anything like that. I think it's starting a conversation about what is viable, and the government wants to hear about how viability should be approached in terms of benchmark land value and the other inputs. But generally, I would say it's a big thumbs up, lots of emphasis on growth, and particularly an emphasis on substantial increase in housing.
Thanks very much indeed, Chris. Some interesting points about neighbourhood plans. One of the things people have to grapple with going forward is the neighbourhood plans, of course, under the basic conditions, don't actually have to comply with the framework. They only have to have regard to it. So for all the draft framework purports to tell neighbourhood plans what they can do, in principle, as a matter of law, it will be open to neighbourhood plan authorities to say, noted, but we won't actually. But so it'll be interesting to see how that plays out. Anyway, I'm going to talk about the next section of the draft entitled Creating High Quality Sustainable Places. And there's a number of chapters within that. I'm necessarily going to have to skip over some of the details. But the first chapter is making effective use of land. And that's notable for a number of reasons, not least that the policies are in the order of L1, L3, L4 and L2. I haven't quite worked out whether that's for good reason or because the lawyers involved can't count. Hopefully that will become apparent in the final draft. But leaving that aside, policies L1 and L3 in particular, the plan-making policies, dial up the emphasis on the effective use of brownfield land, and in particular L3 contains the much vaunted reference to higher densities, particularly in relation to development within reasonable walking distance of a station. Prescribed densities set out of at least 40 dwellings per hectare or 50 dwellings per hectare where the station or stop is defined as well connected. There's also provision L3.4 that development proposals that don't make efficient use of land should be refused. The development management policies are in L2. Of particular note, to my mind, is L2.D, which on the one hand calls for use of airspace above residential commercial premises within settlements to create additional homes, calling for building at height. But then, like much of this document, has caveats, and the caveats are that such proposals must be consistent with the overall street scene, and also maintain safe access and egress for occupiers and users, as well as acceptable living standards for residents and neighbours in terms of access to daylight and sunlight, privacy and external amenity space. So again, another example of some positive, but also then some caveats which will need to be worked out through decision making and possibly court cases. Next, chapter 13 is Green Belt. And I'll cover that in a little bit more detail. So the first few policies are in relation to plan making. This time it does go 1-2 rather than 1-3. So at least they've got the ordering right at one part of the document. GB1 and GB2 largely repeat established principles in relation to plan making and Green Belt. There's reference now to Annex E, which has a rubric for Greenbelt reviews. It also, that same annex, incorporates essentially, as far as I can see, the same text from the PPG on what is and isn't grey belt, and as Paul said, effectively upgrades that PPG into the MPPF, if you believe that the two do have some hierarchical significance, which the Court of Appeal didn't. Then GB3 deals with altering existing greenbelt boundaries, and at GB 3.2 there is emphasis on the importance of local authorities meeting their need in full, except where there are exceptional circumstances, otherwise having regard to all reasonable alternatives. I'll then turn to the decision-making policies in relation to Greenbelt. These start at GB6 and following, and GB7 is the list of development which is not inappropriate in the Greenbelt. For some reason, policy has never said appropriate development. We have this rather tongue twister of not inappropriate development for reasons that I have no idea why that is so, but apparently not inappropriate development is appropriate. Anyway, the list is essentially the same list as what is currently in paragraph 154, but with some notable tweaks. The language in relation to redevelopment of previously developed land has been tweaked. I think that's probably more of a tidying up exercise than anything substantive, as far as I can see. The rules in relation to replacement of existing buildings have been slightly tightened up. That's GB7 1.b. In relation to the other forms of development beyond the usual infilling, redevelopment, PDL, etc., the other forms of development that can be appropriate or not inappropriate if they are consistent with Greenbelt openness and purposes, that's been expanded to include a broader range of infrastructure, rather reflecting what Thea said about the greater emphasis on, for example, water infrastructure and other forms of electricity infrastructure. So now GB 7.1.F point Roman numeral 3, nice and clear, has that wider form of infrastructure gateway for appropriate development. Then GB 7.1G is the grey belt exemption from inappropriate development. That is essentially the same as exists under paragraph 155, albeit differently worded and structured. I should note here that the grey belt definition in the glossary of the framework has also been edited to remove the exemption in relation to footnote 7 policies. Essentially what that does is to clarify that the Secretary of State's view is that the South Staffordshire approach is not to be followed in future, and the Marlow or Wrotham approaches are to be followed. So if there's a showstopper in relation to heritage or flood risk or one of the showstopper policies, they would still defeat a development if they were showstoppers, but they wouldn't preclude it being grey belt. So you'd lose on heritage grounds, not on green belt grounds, essentially. So that's some tidying up that's been done. There's a new exemption, GB 7.1.H, which has 5 different Roman numeral subparagraphs relating to railway station and particular development for housing and mixed-use development within reasonable walking distance of a railway station and subject to certain other criteria. So that's an alternative way through. That kind of development also has to comply with the golden rules in order to be not inappropriate development, just as the grey belt exemption does. The golden rules are set out at GBH, restructured a little, but broadly speaking, identical to the current position as far as I can see. GB 8.3 says this: there are only 3 circumstances in which a site-specific viability assessment may be justified to allow the contributions expected by the golden rules to be adjusted. That's essentially the default 50% or 15% above the development plan. 1 on PDL, 2 for a multi-phase strategic site, and 3 for a development model which is of a wholly different type to that assumed in the viability assessment that informed the development plan. So where there isn't yet a development plan in question, or the development plan's out of date, if you're not PDL or multi-phase strategic site, it's golden rule 1 of no grey belt passport to not inappropriate development. Chapter 14 is described as achieving well-designed places. The key thing I'd like to draw attention to in relation to that is decision-making policy DP3, which sets out a range of key principles for well-defined places. They are, and each one comes with its elaboration, context, livability, climate, nature, movement, built form, public space, and identity. I expect there will be a lot of consideration about how development gives effect to all of those considerations, and whether in some situations they might be competing considerations. So much for that. Then chapter 15 is promoting sustainable transport. Policy TR1 is the vision-led approach to planning for transport. Amongst other things, that introduces and incorporates the connectivity tool, which is now brought into the framework, incorporated by reference. It has been around online for a little while, but now updated and incorporated into the framework. And that's there to, we're told, to inform the assessment and selection of sites for development alongside other relevant evidence. Both in the plan-making policies and in the decision-making policies, there's greater and more explicit reference to active travel. Chris Boardman, our recent guest, will be very pleased to see that. We see reference to supporting more walking, wheeling, cycling, as well as public transport use in TR3.1.B. The TR3.1.A is the classic reference to, and now well known, that development proposals which could generate a significant amount of movement in the context of the area in which they are situated should be in locations that are or can be made sustainable. But it goes on to say this now, by limiting the need to travel, offering a general choice of transport modes for residents and users, unless the nature of the use makes this impracticable. So there's a get out of jail card in relation to development which isn't and can't be made sustainable unless if the nature of the use makes that impracticable. Interesting what that means. One example may be maybe a care home where the residents sometimes say there's some decisions where it's not in a sustainable location, but in certain types of care home, particularly those end of life and dementia, the residents aren't going to be walking into town, albeit the staff and the visitors may be, but residents won't be. So that may be the kind of thing that this policy has in mind. There's also a reference in TR3.1.D in rural areas, opportunities to improve wheeling and cycling and public transport should be taken where they exist. Again, the words where they exist rather suggest that where there aren't such opportunities, that may not necessarily be fatal to a development if the scheme can't improve them. I'm going to skip over, due to time, the chapters concerning promoting healthy communities and pollution, public protection and security, other than to say that the pollution, public protection and security chapter is worth a look at. On one view, it's a little bit more prescriptive than previously in relation to matters such as daylight and sunlight, noise, as reference for impact on chalk streams too. On the other hand, it could simply be that this is what was had in mind as essentially the national development management policies, and that local plan policies wouldn't then need to be prescriptive themselves. But of course, as this is policy, not statute, there may be some scope for local authorities to do so. Anyway, so with that, I'm going to pass over to Paul. I'm particularly interested, Paul, to hear what you think about the increased protection of non-designated heritage assets, the massive expansion of the category of ancient and veteran trees, which are showstoppers, the additional protection to local nature reserves, and the elision of valued and non-valued landscape, and how that might affect the ability of this framework to achieve its desired outcome.
Well, Charlie, in the -6 minutes that are left to me, I shall seek to do my best in relation to some of those points, although I think some of them we'll have to come back to. What I was told viewers is, get up early in the morning, don't get much sleep, read all of this stuff, and don't worry, we're going to stick to our time limits. Sasha had the best idea, of course, which is to stay in Australia and watch cricket and not contribute at all, and tell us that he was leaving it all to us. So I'm just going to do 3 things, and then perhaps a 4th at the end if I feel like it, which is to flag up where you need to look at things and what you need to see. So firstly, I cannot do justice to flood risk, natural environment and historic environment at the end of this. And if you stuck with us so far, thank you. So flood risk. There is lots to say here. First of all, Annex F of MPPF brings in all the stuff about the exceptions test, etc., into MPPF now. It spells annex with the American spelling, which is a particular irritation, but the spell check doesn't seem to have worked on this version of MPPF. But there's lots of bits and bobs on flood risk, and this section of the talk is going to be a bit of a curate's egg. So if you're less than 1 hectare and you're in flood zone 1, according to policy F4, there's no requirement for a site-specific flood risk assessment. Whoever thought there was anyway? Policy F5-2B tells us how to do the sequential test, but is a sensible, consolidated interpretation of the sequential test. And then policy, get this, F5-2B2 rewrites the issue in terms of surface water issues. The amendment that took place to the current version of MPPF, which brought a sensible approach to surface water issues despite 18 months of idiocy, has now been very clearly and in sensible language rewritten. So there's good stuff in relation to flood risk. There's also apparently 2 practice notes on flood risk that have been published, although I haven't read them as yet, so that will be the next episode, no doubt. Natural environment. Big sigh. If it's not broken, why on earth are we trying to fix it? Paragraph 187A and B of current MPPF, which divides up valued landscapes and tells you what they are, and then sets out for everything else that we have to respect the intrinsic character and beauty of the countryside, are well known, was subject to a lot of litigation when MPPF first came forward, and is essentially settled policy. What seems to have happened is that the natural environment section of this document has been rewritten with, if I may say so, deaf spectacles on. There's lots and lots of additional language, lots of additional text, where it's going, I'm not sure. But as I said at the very outset, there is no reference now to things that we are all very familiar with. The problem with that is that that's going to create uncertainty in terms of those bringing forward development, and also potentially raise false hopes for those who wish to oppose it. The natural environment section certainly warrants reading, but is problematical. What I would say is veteran trees. Goodness me. The Woodlands Trust has actually produced a manual to tell you what you need to do in relation to them, but we've now got current MPPF that tells us what veteran trees are. We've got the biodiversity net gain irreplaceable habitats regs, which gives an entirely different definition of veteran trees, and now we've got a third definition in relation to veteran trees. Can I please implore somebody in government to put a definition into PPG as to what on earth is meant by veteran trees and make it consistent, please? At the moment, Charlie's absolutely right. There is an expansion of the definition that's going to be used to frustrate otherwise acceptable development. Historic environment. I said plus ça change at the very outset of all this. It looks like it's quite different. I think Rob Bourne yesterday tweeted, having given evidence in relation to historic environment, everything has changed. I think he was with you, Thea. I'm not sure it has, actually, when you look at it. The test still relates to what significance is. We've still got this balmy binary division between substantial and not substantial harm. That's tucked away in policy HE6. And we still have differential extent of what the benefits are that would outweigh substantial and something that isn't substantial that we used to call less than substantial. I'm not convinced that the chapter on historic environment really is a rewriting of matters. And then just one point, which is a real plea. Others have said what they're going to be writing about this document. I'll tell you what I'm going to be writing about this document. I'm going to be drawing attention to Annex, open brackets, misspelt, close brackets, A of the document. Paragraph 8, which is a massively missed opportunity, which doesn't allow a revisiting of those plans which are going through the transitional arrangements, which you've got through on the 80% or think they have, and then may stick for 5 years in terms of calculation of 5-year housing land supply, notwithstanding they are pitching way, way below standard methodology. That's helpful to no one. We need some sort of sense check on that one. So, flood risk, good stuff. Natural environment, what are we playing at? Historic environment. Plus ça change, rien c'est la défense. Thank you, Charlie.
Thanks, Paul. I'm not so sure about historic environment, and I get, in fact, it's arguable either way. It demonstrates that if this document is probably quite good for the lawyers, even if it may not be good for everybody else. There seems to me to be a presumption against harm to non-designated heritage assets as opposed to a flat balance as before. And
I don't disagree with you, Charlie, but I think that's not intended.
Yeah, well, we'll see if that makes it through. And also, there's now a category of important public benefits that can outweigh. Is it non-substantial harm now, rather than less than substantial harm? NSH.
The harm formerly known as less than substantial.
Indeed. And now there's important public benefits which don't include housing. And will that lead to arguments that there are then sub-important benefits that carry less weight? Lots of things to argue about. But there we are. I don't have any thoughts as to what I'm going to say in a consultation response, or even if I will make a consultation response, because all I want to do now is go to bed and catch up on the sleep that I didn't have last night whilst reading this document with endless cups of coffee. But in the meantime, can I remind you all to make your charitable donation? Please do that, particularly this time of Christmas, because there are those in greater need than all of us, I would venture to say. Have a wonderful Christmas. May 2026 bring you all that you hope for, and we'll see you then.
Happy Christmas.
Dawn.
Happy Christmas.
Happy Christmas.